Every day in Florida, thousands of people are injured in car crashes. They're unexpected, and it can be confusing and even frightening to deal with. If you've been involved in a car crash, there are several things you should know.
Let's talk about car accidents. Did you know that the city of Tampa no longer fills out police reports at the accident scene unless there's an extremely serious injury? It's important for you to document the accident right then and there. Take photographs of the damage to the vehicles. Get the names of any witnesses who may have seen the accident. Get the name of the driver who collided with you, who rear-ended you, who cut in front of you. Oftentimes, what we find is because the Tampa police or other agencies don't really fill out a police report, the at-fault party will apologize to you at the scene, but then later when they're talking with their insurance companies, they will tell a whole different story. The insurance company will take, of course, the at-fault party and their insured's position that they're not at fault for the accident and won't pay your claim. Florida operates, as you may or may not know, Florida operates on a no-fault system. What does that mean? That means that regardless of who's at fault, whether you rear-end somebody or you cut in front of somebody or somebody rear-ends you or somebody pulls out in front of you, your insurance company is responsible for 80% of your medical bills, meaning the ambulance bill, the hospital bill, and any post-hospital treatment, chiropractor, orthopedic surgeon, or otherwise. A lot of people don't know that. They think, well, I wasn't at fault, so I only have to contact the insurance carrier for the person that caused the accident. That's not true. If you're injured, or even if you're not, you need to contact your insurance company or let them know that you've been involved in an accident. Understand this. Under Florida law, it's illegal for your insurance company to raise your rates for an accident that's not your fault and just because you filed a personal injury protection medical claim. Other things you should know. The PIP system is a 3-tier level, meaning this. The first question that's going to be asked when your insurance company takes a statement of you is, do you own a car? If the answer to that is yes, then your insurance company is going to pay 80% of your medical bills and 60% of your lost wages. Let's just say you don't own a car. The next question is, do you live with a resident relative by blood or marriage who owns a car? Do you live with an aunt? Do you live with an uncle? Do you live with your mother, brother, father? If the answer to that question is yes, then guess what? That's the insurance company that's going to pay your personal injury protection benefits. Many people don't know that. Many people don't know, well, I don't own a car and I live with my parents or I live with my brother or I even live with an aunt or an uncle or a brother-in-law. Many people don't know that if you're injured and you have to file a medical claim, that's the insurance company that's going to pay your benefits. The third question, the third tier is, I don't own a motor vehicle and I don't live with a resident relative. Maybe you live by yourself. Then your personal injury protection benefits, your medical bills, your lost wages are going to be paid by the insurance carrier for the motor vehicle that you're riding in as a passenger. If you're a pedestrian, then your medical bills, the 80% of lost wages and 60% of the 80% of medical bills and 60% of lost wages are paid for by the person that ran you over. A lot of people don't know that. It's important. If you're involved in an automobile accident case, I can tell you right now, the insurance industry goes on high alert. They will try to contact you immediately. Oftentimes, they'll even come to the scene of the accident. Back in the day, if you recall, Progressive had cars driving around to the accident scene, trying to get as much information as possible before you could consult with an attorney. Before insurance companies call you, before they ask to take a recorded statement, call Read and Read. We know what you should say, when you should say it, and how you should say it. If you allow an insurance company to take a recorded statement, it oftentimes can and will be used against you later. I'll give you an example. Many times, because of adrenaline, someone's involved in a rear-end accident, and it might even be a minor accident. They snap their neck, they maybe feel a little bit of pain, but nothing too serious. And when asked at the scene by the police officer, do you need an ambulance? Are you hurt? They may very well say, no, not really. I might feel a little twinge in my neck, or I may have a headache coming on as I wait for the police, but I don't really think I need emergency medical treatment. The next day you wake up, you can't move your legs, you can't move your arm, your back, your neck, it's excruciating pain, you're having headaches, but the night of the accident, the insurance company gave you a call and you told them, no, I don't have any injuries. Imagine how that's going to sound when they play a recording of you sitting at trial in the witness stand telling an insurance company, I'm not hurt as a result of this minor accident. I can tell you, I've been there, I've heard it, I've seen how juries react. It's not good. Do yourself and me a favor. Do not give a recorded statement until you talk to me, till you call, read, and read. That's important. And remember, if you have any questions, visit our website at needread.com or give me a call at 813-438-5960. Remember, read and read. It's like having a lawyer in the family.
Visit our website, needread.com, for more information.